Let's see, Adam Edwards, are you on the line today?
Yes, I am.
Okay, good morning, Mr. Edwards.
Good morning.
And Felicity Fitzgerald, are you on the line? All right, looks like there's a box that says Felicity, and it looks like it says it's connecting to audio, so she can't hear us at this point, so we'll just wait just for a second. So sometimes usually what happens when I've seen that in the past, folks usually just have to disconnect and reconnect. So Mr. Edwards, I'd ask for your patience for a little bit while we go to a different matter, and then hopefully she can get connected, and then we'll return to her case, your case.
Yes, Your Honor. I'm Stephanie Lakey.
Okay, good morning, Ms. Lakey. And then Kenton Lakey, are you on the line?
Yes, Your Honor.
All right, good morning to both of you.
Good morning.
We're here on a review. Let me just double check. And Ms. Turnbull, you're on the line also?
Yes, Your Honor, I'm here. Okay,
great. All right, so we're here to review a payment from Mr. Lakey related to the GAL fee.
And so, Your Honor, he has paid. A couple weeks ago, he did make his payment, and so I'm ready to move forward with my report.
Okay. All right. And then Mr. Lakey and Ms. Lakey, did you both receive a copy of that report?
I have not completed it yet. I have not completed it.
Oh, okay. Okay. So you're in a position where you can now proceed and finish and submit the report.
Correct.
Okay, I follow. Do you have a general time frame when you feel when you might have that available?
I think I need about 2 weeks to complete it. Perhaps we could schedule another hearing in 3 to 4 weeks so that they have time to respond.
Okay. How does that sound to you, Miss? I guess it's Miss Jones, correct?
Yes, that's correct.
Okay. How does 4 weeks look for you?
That works for me.
Okay. Mr. Lakey, how about yourself?
Yes, that would be okay.
Actually, could we do it the following? I apologize. Could we do it the following week? I'll be out of town on the 3rd of April.
Yeah, I'm fine with that, Ms. Jones.
Yep, that's fine with me.
Okay, Mr. Lakey?
Yes, that's fine.
All right. Well, Mr. Lakey, thank you for making the payment related to the GAL fee. We'll set this matter over to April 10th for the review of that guardian ad litem review or report. Both parties will have received a copy of that, and we'll have an opportunity to respond, and then we'll review it on that. This is a motion brought by Mr. Edwards related to transferring the case to mandatory mediation. And I just wanted to double check with Mr. Edwards if you served a copy of your motion and any accompanying documents to Ms. Fitzgerald.
Yes, we did serve her with the form for mediation.
Okay. And then let me take a look here. So it looks like I'm looking in the case file. I see a proof of personal service upon Ms. Fitzgerald of a document entitled Notice of Hearing Family Law. The question I have then is, did you serve her with a copy of your motion for an order transferring the case to mandatory mediation?
Yes.
How do I know that?
I mean, it was served to her. I think I just submitted to the court yesterday, though.
Okay. Yeah, just so you're aware, just generally there's a somewhat of a delay upon submission and filing and the document showing up in the electronic file. So if it was filed yesterday, I would not have a copy of that and wouldn't be privy to that. So let me touch base with Miss Fitzgerald. Ms. Fitzgerald, did you receive a copy of Mr. Edwards' motion for an order transferring the case to mandatory mediation?
Yes, Superior Court of Washington Versailles County ordered transferring case of mandatory mediation. I received it on Friday.
All right, very good. And do you have what's your position related to that?
About whether or not I want to transfer.
Yeah, basically what it does is that it transfers the case to mediation, and if the parties can resolve it, fantastic. The case resolved. If the parties can't resolve it through mediation, then the case comes back to court, and then litigation can pursue after that.
Can I ask a question in regards to that?
Sure.
So he submitted his parenting plan, and I disagreed. I submitted my version of the parenting plan, and then he disagreed. Mm-hmm. So we know we are both in disagreement, and we're both not going to agree on each other's parenting schedule. Should we still continue the mediation?
It's a really good question. Have you tried mediation in the past?
No, we have not.
Okay. So mediation is, so here's the court's perspective, is that we try to create as many off-roads as possible for people for the cases to resolve. And one of those off-ramps is mandatory mediation. Oftentimes when parties are at loggerheads or are in disagreement, coming together in a mediation type setting, sometimes there can be points of agreement that can not necessarily resolve the entire case, but can resolve particular issues within, say, a parenting plan. And you may not resolve all the issues, but it winnows down or narrows down the particular issues. So, any movement or any progress that could be made in the case, at least from the court's perspective, is positive in that there's fewer issues to be litigated within court. So I don't know if that answers your question or not.
Yeah, it does answer my question. So I think that, it's definitely something that we could try. We've never done it before. So it's something that it's worth, I think, trying. And then I guess that if it's not something that's agreed upon, we just transfer back to court, correct?
Yep. Right. What'll happen? So if the mediation is ordered and the mediation occurs, and if there's either full agreement or part agreement on particular issues, then usually what's drawn up is some type of document. Some people call it a CR2A, a Civil Rule 2A document, which says, hey, we had a mediation and we're in agreement with these things, and it's listed out and it's specified. If the mediation is unsuccessful, then there would be a document that said mediation occurred on such and such a date, and agreement wasn't reached, and then it comes back to court, and then the parties can proceed to litigate it here.
Okay, and then this mediation is between myself, Adam Edwards, and the mediator. Is that correct?
Could you repeat that again, please?
Is the mediation, sorry, my throat. Is it between myself, Adam Edwards, and the mediator only, correct?
Correct.
Okay.
That's my understanding. Any other questions, Ms. Fitzgerald?
No, that's everything.
Mr. Edwards, do you have any comment or question?
What was the last time I was on here? You had mentioned an app that parents use to communicate with each other through a third party. What was that app?
Oh, shoot, you put me on the spot. It's Our Family Wizard. Our Family Wizard is one. There's a Talking Parents app. That's another. Those are the two options that come to mind.
Thank you. No further questions, Your Honor.
Okay. So let me just double check. So we're here for that, a motion to transfer the case to mandatory mediation. There is a cost involved in that. And Mr. Edwards' motion is asking that it be paid 50-50. So just want to make sure that all parties were aware of that.
How big of a cost is mediation? Do you know?
Off the top of my head, I don't. Madam Clerk, do you have any idea? Okay, sure. Okay. The courtroom clerk indicated, and you may have already heard this from her, but she indicated that she believes it's anywhere between $300 to $400, and they also have a sliding scale depending on your income. So, if you don't make a lot of money, then the sliding scale reduces the fee. If you make a lot of money, then the fee is probably a full fee, and there's probably not a reduction. But generally, that's kind of the range that the clerk is aware of.
Okay.
Okay. So, with regard to that, Mr. Edwards' motion, Ms. Fitzgerald, do you have opposition to that? Are you in agreement, or somewhere in between?
Somewhere in between.
Okay. So, Mr. Edwards, so why don't you go ahead and just tell me why you want the motion, and then Ms. Fitzgerald, you can tell me why you don't want the motion, or at least in part.
So I was regularly having the kids every other weekend, and then there was a Tuesday scheduled that we could not do, and had mentioned previously that we could not take the kids on that Tuesday. Felicity then said that she did not feel comfortable with me taking the kids until it was put into the courts. And so then I drew a parenting plan, which was basically already what we said before about the times I already had them. She disagreed to it once she submitted. Had some strange things like that. I wouldn't be getting the kids on Friday till 7 p.m. And so I disagreed with her motion or her parenting plan. And yeah, now we're here.
Okay. All right. Thanks. Right. And Ms. Fitzgerald, just as far as the motion to submit the case to mediation, tell me what your opposition is.
Basically, he has been, excuse me, like in and out of the kids' life for a while now. And so we agreed upon a set schedule in September, stating that like every other weekend. And so he can come back into the kids' life. And him and his spouse at the time asked me not to go to court with it, basically. And then he doesn't want the kids on Mondays and Tuesdays. He wants to opt out of parenting time on those days, which in a parenting schedule, if they have like a like Memorial Day or like Labor Day, you know, you get them on a Monday, you know, or sometimes a Tuesday. And so basically it's not in the children's best interest for them to have, how do you say it? Like, it doesn't work for their schedule. And so I'm not sure if you're aware of like daycare schedules, but he agreed to half of winter break. And then when it came time for him to pick them up for winter break, he was like, basically, I can't do it. And I agreed in September that I can't take them on Mondays and Tuesdays. And so I'm like, you don't understand how hard it is to find daycare like a day in advance for winter break. So basically I had to almost lose my job in order to care for my children during that time. And then this is just very consistent, where I'm put in a position that's not very fair to me or the children. And so I said, you know, at that point that the best ideal for the kids was to get a court order for the parenting schedule, because I felt like it wouldn't be just put on my shoulders to figure everything out. And where I'm constantly losing my jobs because of another inconsistent adult. And so he decided to file the day before Christmas Eve for this parenting plan. And then when I wrote the parenting plan, I was considering the child's best interest. He had asked me to feed them dinner. And what he isn't aware of, because he's not in the kids' medical side of things, is that my daughter Galaxy is a special needs child who receives occupational therapy, speech therapy, and physical therapy throughout the week. And my son is now also in the same boat. So he's receiving speech as well and occupational therapy, which happens
Mrs.
after
Sherrill,
school.
I apologize. Do you mind if I interrupt just for a quick moment?
Yeah.
So we're here for a motion to transfer the case to mediation, and both of you are sharing some of your views related to the difficulties in your respective positions related to the children and the parenting plan. So those are all topics that would come up in the mediation or during a hearing related to a parenting plan. So I just wanted to just help, at least for my sake, focus your comments related to the mediation piece, whether it's transferred or not, because you said you were kind of partly objecting to that.
Well, it's just, I don't feel like it's just us sitting down with somebody who's going to mediate. I know him, and it's not going to be agreed upon. It's just going to be a fight after fight after fight until somebody basically lays down the law. And that's just it. So.
Okay. All right. Well, certainly, you know, mediation is, it's not something that's forced upon any of the parties. Mediation, I think the best mediations are when people go into a particular mediation and there's flexibility. You have to give something to get something in mediation, because nobody's ever going to get exactly what they want usually in any litigation. And so there's a general idea that, you know, there you have to give some things up to get other things, and there has to be flexibility. So I'm going to grant the motion ordering the case to be transferred to that mandatory mediation. I have addresses listed in Kelso for Mr. Edwards and Centralia for Ms. Fitzgerald. Is that the correct address for you, Ms. Fitzgerald?
Yes, that is the correct.
Great. And then Mr. Edwards' address is the correct one for you?
Yes, it is.
Okay, great. So at this point, I've signed off on that order. And then I'd encourage the parties to contact the clerk's office to get information related to the mediation or mediators. Then the parties can set that up and proceed forward. And again, this type of arrangement best works when there's both parties are joining that process with some flexibility in mind and not entrenched positions. And so if there are entrenched positions, I encourage the parties to kind of loosen up with that and look at the overall case and see what agreements can be reached. And again, I'm not forcing anybody to make any agreements, but at least a good faith effort. And then once the parties have engaged in that, then you'd need to submit either yourselves or the mediation center would submit a document to the court saying, hey, these are the results of the mediation, and then the parties can go from there. Okay, so I signed off on that. If you need a copy of that order, you can check with the clerk's office. And again, you can check with the clerk's office for listing of mediations.
Okay, thank you.
Thank you.
Alyssa Gutierrez,
great.
are you on
Thanks.
the line?
Yeah.
Okay, welcome to you, Ms. Gutierrez. And then Mr. Francisco Gutierrez, are you on the line?
Yes, I am.
Okay, welcome to you, sir. And I see that Mr. Lawrence is present. You can hear me, Mr. Lawrence?
I can.
Okay, great. Just reviewing just briefly, I received a document. It looks like it was dropped off yesterday. I reviewed it this morning. It's a report. Well, it's a report from Kaiser Permanente that Mr. Lawrence submitted related to a service provider providing SED services for Mr. Gutierrez. And I'll ask Ms. Gutierrez, did you receive a copy of that document?
No.
She said no. Thanks.
I
Okay.
apologize, Your Honor. I received it late on Monday, and I was gone most of the day yesterday, and I did file one with the court. I assumed, since the court had told Mr. Gutierrez to provide one to Elisa, that I assumed he had already done so.
Okay. Yes, let me double check with Mr. Gutierrez. Mr. Gutierrez, I see here this is a letter from Ms. Where is it? Pozuelos, and it's dated March 4th. So did you submit that document to Ms. Gutierrez?
No, I did not. I've been having some busy days, and I totally spaced it. It was just over my head. I forgot. That's all.
Okay, so it's interesting that Mr. Lawrence took it upon himself to submit this, which is appreciated, but it's really not his duty. It's Mr. Gutierrez's duty to submit this document. So when I reviewed the case, nothing was filed, and this is kind of key because there's a proposed parenting plan to modify the parenting plan that's been pending since September. And we've been waiting on Mr. Gutierrez to submit documents related to his treatment compliance. And then it sounds like Mr. Gutierrez is just kind of too busy to provide the court the information that it needs. And so the court's a bit frustrated that this is an ongoing process that doesn't seem to take a lot of importance in Mr. Gutierrez's life in getting documents to the court. So
May I say something about getting documents to Elisa? The issue is that there is a no contact order between me and her, so I can't do that.
Can you obtain a letter from the treatment provider more than 2 days before the hearing?
Okay. Yeah, I can try to do that.
So here's where we're at. We have some information from a treatment provider related to Mr. Gutierrez's substance use disorder treatment. And we have very limited information or declarations from the parties related to the parenting plans of what you would like to see. When I reviewed the case last night and again this morning, I saw that there was the petition to modify the parenting plan, and then there was a response to that. So there's very slim information the parties have provided the court. Generally, the court will have declarations from each party of why you want a particular parenting plan and what's in the best interest of the children and giving details. But I don't have a lot of details from either party. And Mr. Lawrence, your report was last submitted before the adequate cause finding was found, correct?
That's right, Your Honor.
Okay. So at this point, Mr. Gutierrez and Ms. Gutierrez, the court's not in a position, especially with the late arrival, which is appreciated that it came, the late arrival of the provider's information related to compliance. I need more information from the parties. And so I'm going to just ask both of you if you can submit declarations related to your proposed parenting plans and why you feel those are in your best interest, and submit those to the court and then supply copies to the other party. I'll hear first from Ms. Gutierrez.
That's fine with me.
Okay, Mr. Gutierrez?
Yeah, that's fine.
Okay. Mr. Gutierrez, when do you think you could submit that document to the court?
By the end of this week, I hope.
Okay. And then you would file that and then provide a copy to Ms. Gutierrez?
I can somehow try to do that. Yeah.
Okay. And then Ms. Gutierrez, as far as your timeframes and getting something submitted to the court after you've received Mr. Gutierrez's document, how long do you think it'll take?
As soon as I receive it, I can file my information.
Okay, all right. Mr. Lawrence, any comment on the timing? I'm thinking March 20th is the timeframe.
That would be fine, Your Honor.
Okay. All right, so Mr. Gutierrez, you'll need to submit to the court no later than Friday, March 8th, your declaration. And then Ms. Gutierrez, you'll have to submit yours no later than March 15th and supplying a copy to Mr. Gutierrez, and also both parties supplying copies to Mr. Lawrence. So we'll be here on March 20th at 9 a.m. to hear the motion for modification of the parenting plan.
All right.
Any questions from either party or any of the parties?
May I ask what number form is that, just to be sure about it?
As far as if you're looking at the Washington Court's website, let me find it for you just a second. I'm at the Washington Court's webpage under the form section. I typed in declaration, and there's not a specific one there. So it's a fairly nondescript document in that it says declaration of, you put the name of the person who's giving the declaration, and then you just write out the information you want to share. So you can look at the court's website to get to kind of the general form, but it's pretty much just an open document that has to be made under the penalty of perjury. So generally that's, you make your statement, and then at the end of your document, there's a language that says that you make the foregoing under the penalty of perjury. Any
Okay.
other questions?
No.
Okay, we'll see everybody on March 20th at 9 a.m. Thank you.
Thank
Come
you,
on,
Your
you
Honor.
can sit there, either side. Just make yourself comfortable and make sure your mouth is in front of the microphone, please. Okay, so I have submitted copies of several documents that the parties, looks like you both reviewed and both signed. Is that correct?
Correct.
Okay, so I have a findings and conclusions about a marriage. I have a final divorce decree. I have a parenting plan related to your 3 children. And then I have a child support worksheet, and then I have a child support order. Now it looks like they've all been signed by the parties. So let me just ask first with Mr. Black, you're the petitioning party. Do you have any questions about any of these documents?
No.
Okay, and you feel comfortable with the court signing off on those and those becoming court orders?
Yes, we're co-parenting very well. We've been separated for about a year and everything's been working out fine.
All right, thank you. Ms. Black, do you feel comfortable if the court were to sign off on these and make them court orders? Okay, do you have any questions? Okay. All right, I'll take a moment to sign all of these, and then once I have signed them, they'll be given to the court clerk. They'll be filed. If you need a copy of them, you can check with the court clerk within probably 3 days and get a copy of them. So I'll take just a moment.
I do have a question about the child support though.
Okay.
We're agreeing of not to do child support and just do 50-50 on everything.
Okay. And that's a part because of the parenting plan is pretty much a 50-50 plan also,
Yes.
right? And so what's your question related to the child support?
If child support would be, if we are able to opt out of the child support and then we just keep everything separated.
So on the proposed order here, there's an indication. Just review it with you. So there's, it looks like both parties signed off on $50 per child for $150 of child support each month.
Yes.
Correct.
Okay.
And is that what you're both comfortable with?
Yeah. We were
But-
just told we were supposed to get that approved by a judge.
Right, right. Okay, and then I also noticed that there was a percentage, percent proportional share for uninsured medical expenses. That it's not 50-50, it's 61% because you're a higher income earner, and then Ms. Black's would be 38% her proportional share. And you're both
I
comfortable with
work
that?
4 hours a week.
4 hours a week. Okay.
Yeah, as of right now, I'm planning on keeping her on my insurance until she's fully get a full-time position. And I'm still just gonna cover the medical stuff
Okay. All right.
on my company.
Okay. And Ms. Black, do you feel that that's a adequate amount of child support with what you're working and then you having the children 50% of the time?
Yeah.
Do you feel like you're making this decision free from duress or threat?
Yeah.
Do you feel pressured in any way to do what you're doing?
No.
Okay. I signed off on those orders. So that'll conclude the hearing for today. All right,
Thank
thanks.
you.
Do we need to do anything else or?
No, if you want copies of them, you can check with the clerk's office in 2 or 3 days and get copies of them if you'd like.
Thank you
Okay.
very much.
All right, thanks. Jablonski's present. Okay, so looks like there was a temporary restraining order that was issued on February 12th, and it restrained Ms. Jablonski. And it was related to concerns of Mr. Vaughn, who's a significant other of Ms. Jablonski. And that the kids, the two children, ages 7 and 9, were placed with Mr. Lyon until the hearing, which is scheduled for today. So far, so good?
Yes.
As far as the history of where we've been?
Yes.
Okay. And then as far as service of the temporary order on Ms. Jablonski, it looks like that was effectuated and occurred on February 13th.
Correct.
Basically the temporary order, and you got a copy of that, correct?
Mm.
Okay. And I guess at this point, I wanted to ask the parties, it sounds like CPS was involved, and has CPS issued any type of findings, or are they still investigating? Are they done? Where are we at?
You go ahead. You go first.
So I've been working with Washington State because there are two different states involved. There's Oregon State and there's Washington State.
Right.
With my social worker, he's come out to the house. He's done observations. He's actually in the Zoom call today. Due to the different states and the kids not being here for observation underneath my care, they're not able to proceed with their job. So I'm asking that the restraining order be dropped. I do have some documents here that I can provide you. They cannot technically put a safety protection plan in place until the kids are underneath my care.
And remind me, Ms. Jablonski, you live in which state?
Washington.
You live in Washington. And Mr. Lyon, you live in Oregon?
Yes.
Okay. And so just going back there, so the CPS has indicated that since the children are in Oregon, they can't do what they need to do as far as like doing a safety plan because the children are not in your home. Is that what you said?
That is correct. So
Okay.
I spoke with my social worker, and actually after this court hearing today, they want to do a brief meeting with his team and try and make up some kind of safety protection plan for when the kids are with me to protect all of us in the home.
Okay. And are there any criminal investigations ongoing that either party's aware of?
No.
Okay. Are you aware of, Mr. Lyon?
I didn't hear the question. I'm sorry.
Are there any criminal investigations pending or ongoing?
Yes, there is.
Okay. Which jurisdiction?
So right now believe that Detective Morris out of Umatilla County is handling the criminal investigation.
Okay.
And the CPS investigation is still ongoing in Oregon as well.
Okay. So you haven't received anything from either party, hasn't received anything from Oregon as far as status of the investigation?
Have I received anything from Oregon? Not
Yeah.
at this time, no.
Okay. Ms. Jablonski?
I reached out to Oregon after the temporary service plan was expired on the 12th, I believe. I had sent a very long email explaining everything, and I never received a response back. I know that my social worker, Scott, who has been working with them, has failed. I mean, not failed, but he's not able to get the information from them because they're not communicating with him.
Okay. And that's, is it Scott Duenas is
Yes.
the social worker from Washington,
Yes.
right? Mr. Lyon, I just want to double check, make sure that can you hear me okay?
I'm having a little bit of difficulty.
We have some hearing devices that make things a lot louder. Would you like to try that?
Yeah, sure.
Okay, let's get you outfitted. We'll pause just for a second. I'll do a speak a little bit, test and see if that works any better.
Yeah, that's a little bit better.
Okay, very good. Okay, so let me just double check. Currently, Ms. Jablonski, you're living in the state of Washington. Are you in Olympia?
Yes.
Okay. And then Mr. Lyon, you're in Pendleton?
Yes.
Okay. All right. And then we're here to see for the temporary restraining orders in place currently. And we're here to make a determination, a couple of different things. One, if the temporary order should become a permanent order for up to a year, that's one option. Another option is to reissue the temporary restraining order to allow CPS investigations or other criminal investigations to kind of take their course and then hear what the results of those investigations are, and then make a determination of what the next, if the temporary order becomes a permanent order. So those are the two options. One, we proceed today on a hearing on a full order, which could result in no restraint, or it could result in a year-long restraint. That's one option. The other option, which I'm leaning towards because we don't have information from CPS, we don't have information from law enforcement, would be to reissue that temporary restraining order that was issued back in February 12th, keep those restraints in place until we have further information from CPS or law enforcement.
I'm in agreement.
Okay. Ms. Jablonski, what's your stance?
Can I provide these documents to you that I do have? Because in order for, like I said, CPS on the Washington state side to do their job, they've already observed the kids down in Oregon with dad, and they've got to see how dad interacts and got to do a one-on-one with him and see how he parents. They have not got to do that with me because the kids aren't in my custody right now. So that's the piece that the Washington side is missing. So I ask, I mean, I'm not the one being accused. The spouse has agreed with the social worker to not be present when the kids are underneath my care throughout the weekend. And the plan is to put a safety plan in place so when the kids are here, that we're all protected.
Okay. So then tell me, what are you asking for specifically as far as?
I'm asking that the restraining order be dropped. I continue my visitation with my children. And that we write up a safety plan on the Washington state side.
And that's Washington state safety plan can occur. What are the conditions for that to occur?
So in order for that to occur, it has to be approved through you guys first off before the children have to be able to come to me in order for us to put that in place.
Okay. And is Mr. Vaughn still in the home?
He is in the home. He is working though. He works for BNSF, so he's away from the home. He's also offered to stay away from the house on the weekends when I have the children underneath my custody. I know Scott and him have talked. I also have a document from him here to present to you if you need it. Agreed.
So is that a document that Mr. Lyon has seen?
I have not.
No.
Okay. So as a general rule, just, you probably know this, but it's a good reminder that if any party has documents that they want the court to look at or review, the other party has to be given an opportunity to look at it so they know what it says, and so they have an opportunity to respond to it.
Okay, I haven't filed anything within the courts yet. These are just messages from Scott, from Chris, and Mr. Lyon when he actually reached out to me after the restraining order was placed. It was broke right after I got served.
What do you mean broke?
He had texted me right after the restraining order was served on me.
So he's not the restrained party. You are.
So I'm physically allowed to talk to him because his name was on the document is where I got kind of confused.
Okay, let's take a look at it. Okay, so the temporary restraining order from February 12th indicates that the restrained party is Tara Jablonski. And it also protects the two children. It goes on to say the restrained person listed in paragraph 3, Mr. Jablonski, is ordered to not go on the grounds of or enter the protected person's home, workplace, vehicle, or school or daycare or school of the children. And that the children would stay with Mr. Lyon until the hearing. Then it talks about service. So those are the restraints. That's the one restraint. So I didn't see in there a restraint as far as communication. I didn't see that. I'm not sure if you're looking at a different document or what have you.
No, I just didn't have the proper understanding of the documents.
Okay. All right. Very good. All right. So let me just ask this. As far as the Oregon CPS investigation and the Umatilla criminal investigation, I know estimates, they generally don't give estimates, but do you have any idea of what particular timeframes that they might have their investigation completed?
No, I can't provide you for that at this time.
It's pretty common. Okay. Ms. Jablonski, do you know if law enforcement has spoken either to you or to Mr. Vaughn?
They have not reached out to us. I
Okay.
was told that that could be because they do not have enough evidence.
Yeah, there could be a whole host of reasons. And has Oregon CPS, have they been in communication with you?
I did speak with them in the beginning of this. I know that Scott has been communicating back and forth with them. So
Okay, and when you say Scott, that's this Washington CPS worker?
that's correct.
Okay. Mr. Duenas, do you have any input?
No, that's fine.
And then, yeah, Scott Duenas, are you on the line?
Yes, Your Honor. Thank you so much.
Any light that you can shed on the issues?
Yes, Your Honor. To what Tara Jablonski had mentioned, it has been quite challenging because the children have not been in Mr. Jablonski's care. There is a parenting plan in place. And in order for me and my team to really gather the information that we need, we would need to observe the children with Tara, and she is accurate in the response that Mr. Vaughn would not be in the home, and that's what we would require too, should the children return back to Ms. Jablonski over the weekends. We will put a safety plan in place while we conduct our investigations and while we also observe the family as a whole.
Okay. Thanks, Mr. Duenas.
You're
So,
welcome, Your
so
Honor.
the parties prior to this restraining order, there was a parenting plan that was issued end of December of 2018. That's what the parties were working under, correct? The parenting plan. Does that sound correct, Mr. Lyon?
Yes.
Ms. Jablonski?
Yes.
And at that time, so it looks like joint decision-making, custodian is Mr. Lyon, and then weekends, Friday, 5 p.m. to Monday at 12 noon. At least that's what's in place currently, correct?
Yes.
Okay. All right, one quick moment. Hold on a second. I guess one question I have for Mr. Jablonski. So there's some concerns related to the well-being and safety of the children, and you've indicated that Mr. Vaughn would not be in the home when the children are present. How can I be assured that that will happen?
He's willing to provide documents from work. And he's willing to sign that document that Scott's team plans to put in place. If that document gets violated, then we'll take it from there, but I don't intend on jeopardizing anything.
Mr. Lyon, any last comments?
Yes, I do actually regarding that. So if you look at our parenting plan, it actually states that the kids are not to be around felons, and Mr. Vaughn has already been a felon and they've been going there for years. So I don't trust Tara's word at all.
I'm just looking at the parenting plan for that provision.
Yeah, I think it's like under like 14 or something.
Okay, I see that. Children shall not be left with or in the presence of sex offenders or felons. Okay. So this is what I think the direction we're going to take today is that I'm going to reissue the temporary restraining order for a period of 2 weeks, come back in 2 weeks and just review what new information we have from CPS or from law enforcement. Sounds like law enforcement isn't doing much. I would have expected they would have maybe had some interviews with the children or something of that nature, but apparently that has not happened. There's been no communication with Mr. Jablonski. I think the nature of the allegations are of a significant enough nature and concern that I am going to issue the temporary order that was originally issued on February 12th and continue that for a period of 2 weeks to come back on the 20th of March to check status of what the status is with the investigations. So I'm going to just take a moment to pen that.
Hey, ask one more thing.
You may.
With the order, is there a no contact type order? Because I haven't talked to my kids in weeks.
No.
Yeah, there's no restraint as far as conversation. It's just my understanding with the restraint order is that it's not to go to the school, home, workplace of Mr. Lyon and the kids. And so we can certainly add a provision related to contact via video conferencing or phone or what have you. Any concerns related to that?
No, I'm perfectly fine with her just calling or texting to reach out to the kids. That's perfectly fine with me.
CPS did put a safety service provider in place, but that thing has expired now. And when I was doing the phone calls, they were monitored. I don't mind them being monitored, but I do mind them being interrupted. And my kid's kind of being coached on what to say, because that has happened.
Okay. Well, certainly any conversation related to any of the allegations would be off limits for any type of conversation. I think that's why probably the monitoring would be proper. Don't want any type of interference with that. But as far as interrupting, I mean, we could set some parameters as far as timeframes and non-interference with the call. I'm fine with that. I think that's important to keep that continuity. I think it's good for the children to have continuity with their mother. So,
Okay.
Any comment on that?
No.
So let me get this document that talks about the reissuance, and then we can talk about the particular provisions that will be included within it. I'm not inclined to put a lot of limitations on the phone calls unless there's a good reason to do so. Is there any concern that if I were to say that Ms. Jablonski may have telephonic and video conferencing contact with the children for reasonable periods, for reasonable times and periods?
Yeah, I'm fine with it.
Okay. And it would just be monitored, and just the prohibition that not to have any discussion related to any of the allegations that serve as the basis of the temporary restraint. Are you okay with that, Ms. Jablonski?
Yeah, the only thing I ask to be put in place as well is for grandma not to interrupt or interfere with the phone conversations.
Did you say grandma?
Yes.
Okay. Any concerns with that, Mr. Lyon?
No.
Okay. So I'm reissuing the temporary order that was issued back on February 12th with all the same restraints. I did carve out just a little bit of clarity where it says respondent, Ms. Jablonski, is specifically permitted to communicate via phone and video conferencing with the minor children. Said communication shall be monitored. No discussion of pending allegations is permitted. No unreasonable interruptions of the communication is permitted. So I think that's pretty clear on its face. And then I indicated that there is a good cause to reissue the order because investigations are continuing by Oregon CPS and the Umatilla County Sheriff's Office. Additional time is needed to finalize those reports. So I've signed off on that. Any questions from either party? Ms. Jablonski? Okay, so we'll be back here on March 20th. The parties are free to appear via Zoom. You're free to appear in person. It doesn't matter to me, whatever your preference is. I just want to know that you have that option.
Okay, yeah, that was what my one question was about.
Yeah. Any questions? Okay.
At this time.
All right, that'll conclude the hearing. If you'd bring up the headset, that'd be appreciated. Thank
Yeah,
you.
no problem.
Cause number. And we'll just make sure everybody's present. We'll first call out Christina Allgood. Are you present? Okay. Looks like Ms. Allgood is present. She's here in the courtroom. Feel free to take a seat and then just position yourself close to that microphone. And then Keith Holland, are you here?
Yes, sir, I am.
Okay, all right. I see Mr. Holland there. And then, sir, you're free to sit there. That's great. But I just ask that you not participate. So, thanks.
No problem.
All right. And so we have Ms. Looney present. We're here on, let me get my notes 1 second. Finalization of a dissolution and also child support. And so as far as child support, let's hear from Ms. Looney first, then we can hear from Ms. Allgood and then from Mr. Holland. Ms. Looney?
Thank you, Your Honor. So the state did present proposed worksheets as well as final child support order. We had information available to us for Mr. Holland from 2016 employment security data. We did use that information. He earned an average wage of $15.98. So we did calculate that at 35 hours per week, giving him a net monthly income of $24.29. Ms. Allgood is a recent TANF recipient. So we did indicate that she is at the TANF wages according to the RCW, which put her at a net income of $20.35. The transfer payment that we're requesting is $447 per month from Mr. Holland to Ms. Allgood. There is one child only, and we're asking that the payments begin starting December of 2023. That's when the child began receiving TANF benefits.
What was the date again? 2023, what month?
December of 2023, Your Honor.
Thank you.
We did, after we submitted our proposed orders, receive information from Mr. Holland that he's applied for Social Security disability, but he has not been approved. So we do not have a different income that we can use to calculate support. So we are requesting that the order be entered as we've presented it.
Okay. Thank you, Ms. Looney. Ms. Allgood, any comments related to the child support issue?
Not anything in particular. I am very aware Mr. Holland did just have a pretty significant back surgery. So that is his reason for applying for disability. Previously denied, but a good time to look further at it. He has not worked in approximately 6 years. So I think the child support amount as is will be difficult for him. And as of the 10th payments, the cash assistance, March 1st was my last. I have done well enough in my client finding for work that I no longer need it.
Okay. All right. Thank you. Mr. Holland?
Yes, sir.
What's your input related to the child support issue?
I was a stay-at-home father. My mother helped us out when neither one of us were working. I'm currently unemployed. I filed paperwork with the court that showed my work history and showed that I hadn't worked in a number of years. So right now, child support, there's no way for me to pay child support.
And how are you currently supporting yourself?
My mother is supporting me.
Okay. You filed a financial declaration where you indicated your housing cost was $800 a month for rent?
No.
Okay.
No, there is no rent. The house is paid for.
Okay. So I'm just curious. Yeah, you wrote that in your declaration. You said, my mother pays all my bills until I can get my disability. But then also you said where it says, tell the court what your monthly expenses are. And then it says housing expense, $800. Then they have utilities and food. And those are your total expenses, about $1,800 per month. Is that accurate or not accurate?
That's accurate, except for there is no rent. So if I filed or put something in the wrong spot, that's on me.
Okay. Okay. All right. Thank you. Ms. Looney, any additional comment on your end?
Your Honor, the TANF is paid through the end of March. So when we calculated our order, we were looking at the fact that we could not do any sort of a deviation because the child was receiving TANF benefits. At this point, if Your Honor is willing to consider doing a deviation for Mr. Holland, we would be requesting that we have a back judgment at the full amount of support from December through March. That would require us to provide you with some updated orders, but if Your Honor is willing to consider changing the ongoing payment, we would leave that up to your discretion.
And you said if the court's willing to consider what payment, did you say?
If you're willing to consider a downward deviation based on Mr. Holland's testimony today, we would not have a specific interest in the ongoing payment, but we would need to have a judgment amount for the back support during the time when the child was receiving TANF from December of 2023 through the end of March of 2024.
Okay, and that would be in that same amount that you've proposed at 447?
That's correct, Your Honor, 447 per month.
Okay. I apologize. The audio is that last comment. Could you repeat that last comment?
Oh, just the 447 per month would be the request.
Okay. All right. Thanks. And Ms. Allgood, you indicated that you made mention of the back surgery and hadn't worked for 6 years and the like. What's your position of allowing a downward deviation of the child support amount?
I would support that. My reason being also that with child visitation, Mr. Holland still resides in the state of Kentucky, which puts visitation at travel costs for both he and I. And if lowering the child support amount helps him cover his travel costs to see his son, I would rather that money be spent in that arena.
Thanks. And Ms. Linney, when you talk about a downward deviation, it sounds like Mr. Holland, I looked at his employment security data information, and it doesn't look like any really significant income for a number of years. And so what amount are you making a proposal for a downward deviation or allowing the court to adjust that?
We would leave that to your discretion, Your Honor.
Okay. So there's a minimum amount of $50 a month. Ms. Allgood, or I just want to check with you what you think about that, or does it need to be a higher amount?
Given he is not working, and I don't believe him capable of working right this instant, he has a lot of healing to do, a lot of recovery remaining. I'm okay with that. And there's always later. If things change later, we can always modify later. So right now I find it most important that, he gets better and has funds available to see his son.
To visit. Okay. Okay, so I'm inclined to grant that request of the $50 per month, and we're just make sure I'm on the right page here.
So, Your Honor, we can provide updated orders that include that for the ongoing payment with a start date of April 1st. If we just want to set a presentation date out a couple of weeks, we can get that out to the parties.
Okay, so Ms. Looney has indicated that the orders that she submitted need to be modified because it's different than what she was asking for. So she's asking that it be set out for a period of time and for those orders to be adjusted to reflect $50 per month.
Mm-hmm.
And that the start date for the $50 a month would be April 1. I'm a little bit concerned about the TANF being in place from December to March, and then placing that on Mr. Holland based on, it sounds like, his back issues and ongoing inability to work. Ms. Looney, can you address that?
Your Honor, the statute would require us as the state to request the full payment amount, as there's no deviation that we have evidence of that we could use. If Your Honor is ordering that the TANF period be reduced as well, then I can include that in the order as a judgment period. Or if Your Honor prefers to have the start date be December for the $50 per month, we could do that as well.
Okay. All right, thank you. As far as the back TANF, I'm going to deny that request from December to March. And then we'll have the start of the $50 per month starting on April 1. And then hopefully then Mr. Holland can heal, and then he can utilize the monies that he does have to come out and visit the child. I think that's important. So Ms. Looney, if you could prepare those orders. Do you need any clarification from me as far as those adjustments?
I don't, Your Honor. I just want to inform the court and the parties that if the TANF period is not covered in our final order, that the parents will be getting contacted by Division of Child Support to do an administrative order for that period of time, because they would be seeking to collect back support. My understanding would be that they would look at a $50 order would be the most likely at that time, but it would just be a separate order that they would need to participate in the process for.
Okay, so Division of Child Support may be contacting the parties related to that period of time. Turnaround time for the parties to come back with those revised orders, and just with those revised orders, they would say that there's no back TANF period, that they're $50 a month. It starts on April 1st. And if Ms. Looney supplies you with those copies and you agree, you can sign off on those and submit it to the court, and the court can sign off on them, and the hearing could be stricken. You wouldn't have to come to court. However, if you are concerned with those proposed orders that Ms. Looney gives to you, then you could be here at court to express your concern. So timeframes, Ms. Looney, 2 weeks or 1 week?
2 weeks. I believe we have, let me just check my file really quickly. I don't have an email address for either party, so if they can call our office and give those to us, we can get the orders to them more quickly. If not, I would say at least 3 weeks, as Mr. Holland does live out of state. We would need to mail those.
Okay. Mr. Holland, do you have an email address that you could potentially share? Some people are concerned about sharing it on Zoom with a whole bunch of people in court. I get that. Another option.
No, I have one. I have one.
Okay. What's your comfort level of just sharing it with over Zoom?
That's
now?
fine.
Okay. Go
At gmail.com.
Okay.
And Ms. Allgood, what's your comfort level?
Oh, I'm fine.
Okay.
I'll spell mine. It is CHRI@iCloud.com.
Okay, I have those, and we can send out those proposed orders by email as well as mail. And if we set it out 2 weeks, that should hopefully give everyone enough time to get them and review them. And if they agree, they can send us back a signature, and we can send that for ex parte sooner if we are able to.
Okay.
Are we able to e-sign and send them back?
Fortunately, our office does not have the ability to do e-sign.
I mean, one option that I've seen people do is that you could sign the document and then scan them and then
Email it back.
Yeah.
Okay.
Yeah, or just use your phone to take a picture. Most iPhones have the ability to do a PDF with in the notes app.
Perfect. Perfect.
All right. So we'll set the hearing for March 20th. Again, if the parties sign off on that document, then you don't need to be here on March 20th at 9 a.m. It'll be, your signature will carry the day. Mr. Holland, do you have any questions on the child support issues so far?
Yeah, what would the back pay be for the TANF?
If I had ordered it, it would have been 4 months at $447 a month.
But you're not ordering it?
Correct.
So it'll be just the child support beginning in April?
Correct.
Okay.
Any other questions?
No, sir.
Okay. All right. Thank you. Then I just want to touch base on the next issue. Doesn't pertain to Ms. Looney directly. I have proposed orders of findings and conclusions about a marriage, a final divorce decree, and a parenting plan that Ms. Allgood has submitted. Mr. Holland, did you receive copies of those documents?
I did receive the original. She said she was going to amend them, and I never received any other copies.
Okay. So there was a default order entered on December 14th of 2023. Mr. Holland, are you in agreement with these proposed orders or disagreement with these proposed orders?
Under what I've read, I'm in a disagreement with the orders.
Okay. And so right now there's a default order that says Ms. Allgood wins and you lose, basically. And so,
yeah.
So without you having moved to change that or that order, then that order of default still continues. So Ms. Allgood is technically entitled to the signing of those documents if the documents mirror the initial pleadings that you filed, which was the basis of the default order. If there's any change from those initial pleadings until the ones that I have here, I wouldn't be able to enter those because they're different. So with the parenting plan, I noticed that there were some differences. And so I just wanted to touch base on that because, and they're minor. There's minor differences between the August 31st, 2023 proposed parenting plan and today's order. And I'll tell you why, so you can kind of grasp this maybe more clearly, is that sometimes when lawsuits are filed, one party will want X, Y, and Z. And the other party that gets that says, well, I'm okay with that. I'm not even going to answer. And so they don't answer. Enough time passes by. The initial person that wants the X, Y, and Z, they come to court and said, we don't have any answer. They don't care. There's been no response. Give me what I asked for. So then the court says, okay, we didn't get a response from Mr. Holland. So there's an assumption that Mr. Holland was in agreement with what you had filed. So since that's the case, then there's that assumption that the responding party is in agreement with what you filed. So therefore, if there's a change from that initial order, then that same assumption of agreement doesn't apply. Does that make sense?
Yeah.
Okay. So with the parenting plan, I did notice that there were some slight variations, in particular on the findings of the reasons for the limitations. I think there was one extra box checked that wasn't checked in the first one. So if you're in agreement that those changes that from the original should be removed, and so the original and the new one.
And I spoke with the facilitator about that and had said that I would be happy to, because I think in filling paperwork out months apart, sometimes you maybe forget a little bit, but I would be happy to make the final match the original.
Okay. All right. So Mr. Holland, do you have any questions or comments at this point?
Yeah, I think visitations, supervised visitations with my son is unacceptable. There's never been any issue with my son and myself. I watched him every day. So, you know, I don't understand that. And I don't think it's appropriate.
So here's my issue, Mr. Holland. I hear what you're saying as far as your disagreement with the parenting plan. My issue stems from the fact there was when the case first started, there was a summons and a petition for dissolution of proposed parenting plan that was filed, and then there's a return of service indicating that you'd been served those documents on or about the 5th of October. And then come middle of December, Ms. Allgood filed a motion for default saying, hey, I served all these documents, parenting plan, other documents, and I haven't got a response. And therefore, I should get what I want and get the default. So a default order was entered on December 14th of 2023. And then the only time—
And the reason I didn't respond was because she said she was going to make amendments to it.
Mm-hmm. So at this point,
So
go ahead.
if those amendments haven't been made, then, you know, I wouldn't agree with it.
So the only document that I have filed, I think, from you, Mr. Holland, is your financial declaration that you submitted on February 15th. Have you submitted any other documents for the court to consider your position in the case?
No, because she told me she was going to make the amendments.
Okay.
So I took her at her word.
So there was a summons that was filed that you were served with, which indicated that there was a lawsuit starting, and that it tells you to follow these certain steps. And it says fill out a response to the petition about a marriage, and go to these different other help sites that can give you some assistance, serve a copy of a response to the petitioner, and it tells you that you have to do that within X number of days. And so when you didn't respond, then the court made an assumption that you were okay with what she had filed, notwithstanding any communication that happened outside of court, because the court wouldn't know about that because nothing's been filed. So I think I'm inclined to grant the relief that Ms. Allgood has requested based on that default, because the default had been entered, and if you felt it was in error, then you could have filed a motion asking that it be changed or lifted so you could have your voice heard and litigate the issue, but we haven't heard from you. Can you tell me why you didn't submit anything for the court to consider related to that?
Because I took her word that she was going to modify the paperwork.
Okay. Ms. Allgood, any comments?
He had requested modifications be made, and we had discussed at length. There were issues in the marriage. My 2 older children emotionally damaged by some of his behaviors and actions. Our son, our youngest, exposed to much of that. So part of the modifications he requested for me required things like parenting classes, counseling, anger management. There were steps I wanted to see from him before I was willing to remove things like supervised visitation. He was here during the holiday season to see the children over Christmas, and I did everything I could and exercised my due diligence in allowing him to spend time with the kids. For the most part, went well, but you know, a lot of that was with my 19-year-old daughter present, which was where her brothers felt safest in his care. It was also with her. And I'm not beyond modifying at a later date, but I want to continue to see Mr. Holland doing better, trying to be better, and working on his temperament and responses to real life situations.
Thanks. So there's—
Well, I think she's seen a lot of that already. And I've already completed anger management, and I completed a parenting class, and I regularly see a psychiatrist and a therapist.
All right, thank you. So there's a tenet or a principle in the law that, which you've probably heard of, it's just due process. It's the opportunity to be heard, be given notice, have your voice heard in a proceeding. Default orders are not uncommon. They happen with regularity. And there's a tendency to want to hear everybody's voice in a proceeding before making a final decision. And this would be a final parenting plan that would be put in place. So there's a degree to which, with Mr. Holland's presence here today, of maybe holding off on the final parenting plan to allow him to make some type of motion related to the default order. So I'm considering that because he's made himself present today and expressed some thoughts related to the matter. So let me just hear from Ms. Allgood if you have any input on that.
Does that push back the date of divorce? Are we still able to finalize dissolution?
Yes, generally yes, because as a general rule, a dissolution will just address property division and money issues. It does, I believe, talk about a parenting plan, but
I believe the parenting plan was fairly open-ended, suggesting, I think it was quarterly travel for either him or, myself traveling to him with the baby, something to that effect. So I feel like for now that was pretty open-ended.
But I'm sorry to interrupt. What I don't understand is if there's supervised visitation, how is that? How would that work? If he comes here to spend time with me and there's supervised visitation, how does that work?
Well, kind of the same way I think it did while you were visiting. Sometimes we'll be present, sometimes not, and it's not like I didn't allow you time with the children. I would also like to point out that the last day you spent with the children, you totaled a vehicle with all 3 of them in it. I have reasons to be concerned because I feel like you're not always focused on their utmost safety. You get caught in your head and you're thinking about other things. And to me, that's a big deal.
Well, accidents are accidents. Accidents happen.
Yeah, right after turning the wrong way down a one-way street. These are things you need to be paying attention to, I feel, when you have the children in your care. And these are my reasons for not feeling entirely safe, given the past. I have an obligation as their mom to look out for them. And unfortunately, I am given some pause with some of the things that have transpired.
okay, so I appreciate the input from the parties. So under the proposed parenting plan, Ms. Allgood posed a question related, can we finalize other aspects of the case? In response to that question, there's that similar tenet of having every party's voice heard, yet there's rules that are in place that govern default orders, and if people don't follow them, then they don't follow them. One question I had on the proposed parenting plan, it indicates that Ms. Allgood is designated as the custodial parent, and then the limited schedule for parenting time for Mr. Holland would be that'd be supervised contact with the children. Supervisor would be Bradford Conrad, and that school breaks, that time, that would be time some of the visitation could occur, and that the visits in Washington are preferred, and the supervisor should be aware of emotional manipulations and aggressive behavior. So there's no real clear timeframes other than school breaks as far as visitations.
I thought quarterly had been sort of implied in there also somewhere.
And he's not currently in school.
Yeah, the baby is not currently in school. That's true.
Sure.
And this is for my son. We're not talking about the other 2 children. What she decides to have me, if they want to visit with me, that's a total different issue that has nothing to do with this case.
Is the child that you have in common, is that Joseph? Okay. Joseph is the child. Okay.
And as far as it goes, as it is now, they don't even speak to me. So, they were fine when I visited, but as of, phone visitations with Joseph, neither one of the other children feel that they want to correspond with me.
Okay, and Joseph is 3, right?
He just
Four.
turned 4.
4.
4 now, okay. There's the property in Boonville, Kentucky, as far as, has that home been sold?
No, it has not.
Okay, is this sell pending?
I don't believe they've listed it yet. Mr. Holland intended to move. He is currently on 5-year probation in Kentucky. He initially was trying to transfer his probation here.
Still, I'm trying to transfer the probation.
He was going to sell that property, and then the 25,000 I was asking out of the sale of that property.
Okay. Mr. Holland, when did you first become aware of the default order?
Today.
What?
So I mentioned earlier that there's this due process. It generally requires notice and opportunity to be heard. The default order gave notice, gave an opportunity to be heard. Mr. Holland did not avail himself of that opportunity and just sat on it and didn't do anything. So default order was entered. Mr. Holland lives in Kentucky. The child of the parties is 4 years old, resides primarily with mother, Miss Allgood, with Mr. Holland occasionally traveling to Washington State for a visit. He sounds like there's some probationary requirements that at least require him to be in Kentucky. And if a interstate compact was granted, then he could potentially move to the state of Washington. It sounds like there's a community property home that's in Kentucky that if he were to move, that potentially would be sold. And if it's community property, it's divisible between the parties as community partners. And there's some issues and concerns related to Mr. Holland, mental evaluation, anger management, things of that nature that have been raised in the pleadings. And there's concern for just the well-being of the children, or child, pardon me. There's children, but child in this instance. While the default order is in place, Mr. Holland indicates that he became aware of that default order today. Okay, I'll take that at face value. Here's my leaning. I'll tell you why that I'm leaning this way. I'm leaning towards if Mr. Holland wants to file a motion to vacate that order, I would give him some time to vacate that order. It's not a guarantee that the order is going to be vacated. That motion could be considered, and if it's denied, then the order for default would stand, and then relief could be granted that was requested by Ms. Allgood. If the motion for vacation of the default order is granted, then that would open things up. Mr. Holland would have an opportunity to file responsive documents related to a parenting plan and final dissolution. Will it take more time? Yes. Does it require more stress and concern in people's lives? Yes. And it allows all parties to have a say. And that's considering if the default order, vacation of the default order was granted. My philosophy is that there's almost always a better outcome in the long run. And the outcome may be exactly the same that Ms. Allgood has requested initially, even with the input from all parties, or it may be different, or maybe altered somewhat, or a great deal, I'm not sure. So I think I'm leaning towards that, to allow Mr. Holland a discrete period of time for him to file a motion if he wants to vacate the default order. And that's the only provision that I'm allowing here today. So I'm going to hold off on signing on the orders, that if he wants to file that motion for default, he can. A motion for vacation of default, he can. He would have to have it filed no later than March 15th. And that would have to be filed with the courts on March 15th, no later. If it's filed beyond that, then it's too late. You have to have it filed by March 15th. And if then the motion would be considered, it would be considered ex parte, meaning just the court would read the pleading, look at the file, and make a decision. If the court grants that vacation, then either party could note it up for a hearing to make a determination on the parenting plan and division of property. If the order is denied to vacate the default order, then the default's in place, and then Ms. Allgood could note it up for the default presentation just as it was today. So I think that's where I'm going to fall on that particular issue. Mr. Holland, do you have any questions?
No, I just need to know how I can get the paperwork that I need to file.
There's a couple of different resources that you can turn to. You can turn to a website. It's called washingtonlawhelp.org. That's one option, washingtonlawhelp.org. Another option is the CLEAR hotline. The CLEAR hotline is a hotline that attorneys, you can call and speak to an attorney and they can give you resources. Another resource is the Washington Court website, the court's website under dissolution forms and forms for default and the like. So those are three resources that I can present to you and offer.
What's it called? A motion to,
It's a vacation of the default order.
vacation of a default order. Okay. Thank you, sir.
So I mean, I'm just going to change the date a little bit. Instead of the 15th of March, I'm going to change it to the 20th of March for the deadline. So it'll be 2 full weeks for Mr. Holland to have that submitted to the court. And then I'd ask Ms. Allgood that you would just need to take note of what the court's decision is related to that vacation motion. And if it's denied, then you could note it up for a presentation and for finalization. If it's granted, then the case is open at that time and either party can make a motion related to a parenting plan, division of property and the like.
So I have a question. If Mr. Holland and I were to kind of go back to basics, if we were to go through the dissolution, parenting plan, all of that paperwork together, if we were to fill it out in tandem and in agreement, could we then turn that in?
Yes.
And would we have that 90-day waiting period again, or are we just,
No 90-day waiting period.
okay.
Yeah, if
So if Mr. Holland is interested in maybe reworking those documents together,
I'm more than willing to work with her. Absolutely.
so I'll get a hold of the documents and then maybe you and I can plan an extended video chat and work through each page, what we are both interested in, what works best, and what we're comfortable with.
Yeah, I'm willing to do that.
Okay.
Yeah, and certainly that's I'm glad you bring that up. It's all good because anytime parties can agree to something, you all are much closer to the situation. You know the situation much better than I ever will. So if the parties can make an agreement and it's a non-duress and everybody feels comfortable with that, yeah, definitely those could be submitted and the court would just sign off on them.
Okay. I think we've come a long way from the initial filing to where we sit today. We don't agree on everything, but I don't expect to. I think we're both reasonable enough to understand that.
Okay.
I agree.
All right. So, Madam Clerk. Yeah. I think they probably would. Yeah. Okay. So any questions on the next steps?
No, I think I need a new packet.
Yeah.
I think that's it.
Yeah. Mr. Holland, any questions?
How much time do we have to do this?
Well, if we're going to fill out paperwork in agreement, I mean, as soon as you and I fill it out, I'll make the copy, have you served again. Or does it have to, do I have to have him served if if he agrees with it?
No.
No, it doesn't require regular service. So I'll just send you a copy, you sign it, you send it back and off we go. So but he would send it to the court and not directly to me.
Either or.
Okay.
Either or.
Okay, so we've got it either way. I'll get us the packet, we'll video chat, fill it out. I'll send you a copy for signature and then we'll get them turned in as agreed upon.
Sounds good.
Okay.
And then, Mr. Holland, just be aware that there's that March 20th deadline that if you do intend to file the motion to vacate the default order, that's the deadline.
If we're going to go ahead and redo the paperwork, I don't think there's any reason to file that motion if we're going to sit down and arbitrate this ourselves.
Okay. Yeah, just want to make sure you're aware of that. Okay.
Okay.
So I think I appreciate the discussion with the court and with the parties. I'm not going to set a date. So the parties are going to try to make some efforts to come to an agreement. And then depending on that, there may be a motion filed, there may not, and we'll just go from there. Okay.
Okay.
All right. That'll conclude the hearing for today. Thank you.
Okay, thank you.
Thank you.
I'll be in touch.
I'll ask if Ashley
All right.
Fleischman is on the line.
I am.
Okay, welcome to you, Ms. Fleischman. Nathan Smith, are you on the line?
Yes, Your Honor, I am.
Okay, welcome, Mr. Smith. All right, we are here today for review of a parenting plan. Ms. Day is the guardian ad litem, just double checking if she's on the line. Okay, no response. So
Do we still, I'm sorry.
Oh, pardon me, go ahead.
I'm sorry. Do we still have Miss Day as our guardian ad litem? Because I was under the impression we were done with that and we haven't talked to her in I don't know how long.
Yeah, probably. It's still listed on the case file, so I just made mention of it just in case she was present.
I see.
All right, so there was it looks like procedurally, a historical procedure review is that adequate cause was found back on October 4th of 2023 to alter a parenting plan. And the basis of that was that at the time Mr. Smith was incarcerated, he's not now. And so he was released. And so so things have changed. And there was a temporary parenting plan entered in May 8th of 2023 that allowed some visits on Saturdays and video visits. And then Ms. Fleischman submitted a proposed parenting plan February 22nd. And it looks like she served a copy of that on Mr. Smith. And so that's kind of where we're at. And so let me just touch base with the parties to make sure I know what your understanding of the purpose of today's hearing. Mr. Smith, tell me what your understanding of today's hearing is.
Yeah, I was with the new parent plan. After I was served with it, I contacted Ashley because we do speak quite regularly now on the phone. We're able to communicate. And as far as I was concerned from the telephone calls, we're both totally in agreement on her proposed parenting plan. What she asked for was the same thing that I was asking for.
Right. Okay. And
so as of right now, I'm in complete agreement with her and the right now.
So, Mr. Smith, I think I heard everything that you said, but there was a little bit of delay and kind of herky-jerky audio that came through. Would you do me a favor just to make sure that I hear you clearly? Maybe you could turn off your video. I appreciate that you have it on. Maybe you could turn it off because that'll reduce the bandwidth, and then I'll be able to hear more clearly your comments. Okay, so just confirming, Mr. Smith, what I heard you say is that you're in general agreement with the parenting plan, and that's what I heard.
Yes.
Okay, and the parenting plan, that's the one that was served on you back on February 22nd, correct?
Yes.
And this pertains to your child, Dustin, who's 12?
Yes, Your Honor.
Okay, and it lists that there'd be limited decision-making to Ms. Fleischman for school and education and non-emergency healthcare. Does that sound sound right?
Yeah, all I wanted was just to be informed of what's going on. You know what I mean? Like, cause my son, he's been displaying a lot of behavioral issues at school.
Yeah.
And Ashley has done a really good job of contacting me and, saying, hey, your son, I just want to be able to communicate with him when he has these kind of things, because I myself dealt with a lot of behavioral issues. So I want to be involved with that kind of stuff. I'm not trying to come in and, be the power parent, you know what I mean? And what I say goes, nothing like that. I just want to just be involved.
Okay. You just want to be aware and know what's going on.
Right.
Okay. And then it has alternating weekend visitation, Friday 5 p.m. to Sunday at 5 p.m. Does that sound right?
Yep.
Okay.
As my schedule allows, though, because like I've explained to the court before and to Ashley, I work 12-hour rotating shifts at a paper mill, at Wana Paper Mill. So I don't have every weekend off.
Sure.
So, but me and Ashley have talked, and as my days off come up, if I'm able to have Dustin and it works for her, then, yeah, but it will be a rotating schedule.
Gotcha. Okay. And then there's a listing of just different holidays, and it looks like it's kind of alternating between the parties.
Yeah.
All right.
Yep.
All right. And then, yeah, so that's the parenting plan that you're comfortable with. Is that correct?
Yeah, 100% comfortable with it.
Okay. Ms. Fleischman, any comments?
Yeah, I mean, I'm good with everything there. My only concern is I really just want to be on a schedule. And it's we could never have a schedule. I mean, and I understand Mr. Smith's work schedule. I don't know. I feel like every other weekend, maybe he could not do overtime. I don't know if it's only overtime. My understanding, and correct me if I'm wrong, Nate, but my understanding is that you find out on Fridays if you work overtime on the weekends. So, I mean, I feel like if maybe we had a set schedule and it was your weekend, maybe that Friday you could let them know, hey, I have my son this weekend. I can't work overtime.
So because I'm the low man on the totem pole at the paper mill and we're shorthanded, I'm the fifth hand. There's mandatory overtime. I don't have a choice. If I'm scheduled to work overtime, it's considered a scheduled work day. There's nothing. I've tried to explain this to you many times. I don't have that choice.
Okay. Well, I mean, I guess we'll just do what we can do, but I guess making it every other weekend isn't going to happen. So we shouldn't make that what it is because it's not every other weekend. It's just going to be whenever his schedule allows. So I don't know.
Yeah, and let me just share this little bit of information with the parties, is that often a parenting plan will be put in place, and that's kind of the base level. It gives recognition to life is messy, it's not clear cut, life happens, right? You can't always exercise the parenting time as laid out in the parenting plan. So what I see often is that parents will deviate from the parenting plan and then just agree to, okay, we'll have visitation on such and such a date. But if there's ever a disagreement about visitation, then the parenting plan controls. So parties, if they're able to get along and make agreements regarding the parenting plan, great. That allows for that parenting time to occur. But if there's ever a disagreement, then the baseline controlling document is the provisions of the parenting plan. Does that make sense?
Yes.
Yeah.
Okay. So, we're here today because there's a proposed parenting plan filed by Ms. Fleischman, and I'm not sure. You may want to move forward with that today. I heard some hesitation, but I'm not sure what the parties are wanting to do.
No, we can move forward.
Okay. All right. And Mr. Smith, are you good with that?
Yes, I am.
Okay. So I think what I'll do, there was a proposed order that was filed by Ms. Fleischman, and I think I can print that off and I can do some whiteout, and then I can sign that document and just note that both parties approved of that during the hearing via Zoom, and that thereafter I'll sign it and then submit it to the clerk, and it'll be filed.
Okay.
Okay.
Great. I will do that. So let me just write myself a quick little note here.
So there's nothing we need to do from here on out unless we disagree on something, then we obviously will just do the right paperwork and come in front of the court again.
Right. So what'll happen is that I'll sign that order. If you want to get a copy of the order, it'll be identical to the one that Ms. Fleischman filed. I'll sign it. If you need a copy of it, you feel free to stop by the clerk's office in 2 to 3 days, get a copy. Then that becomes the controlling document. And if there's ever a time where the parties feel that it needs to be adjusted, you can file a motion for adequate cause and a motion to petition to modify a parenting plan. But otherwise, that parenting plan that's been submitted, I'll sign it, and it'll be the controlling document in the case.
Okay, perfect.
Okay. Mr. Smith, any questions on your end?
No, not at all.
Okay. All right. Thank you both. I'll take that action, and then if you want to get a copy of it, you can contact the clerk's office.
Thank you.
Thank you.
Thank you both. I'll ask if Michael Miller is on the line today. Mr. Miller?
Yes, I'm here, Your Honor.
Okay. Welcome to you, sir. And then Ms. Mezquita, are you on the line today?
Yes, I'm here.
Okay. Welcome to you, ma'am. All right. So as far as today, it looks like historically there was a petition for a parenting plan filed by Mr. Miller back in December of 2022. Both parties submitted proposed parenting plans. There were some concerns at that time. Both parties had different ideas as far as a parenting plan, what it should look like. We were most recently here, looks like on end of December of 2023. And there was some sense that the parties were potentially able to work out an agreement for a parenting plan. And I looked in the file and I didn't see any proposed orders. So I'm making an assumption, you can correct me if I'm wrong, that there's not an agreement as to the parenting plan. Is that so? Mr. Miller, I'll hear from you, and then I'll hear from you, Ms. Amezquita.
Okay. So in my parenting plan, I was requesting that there be supervised visitations as there have been, due to having to file restraining orders against, first, it was her boyfriend, the person that was living with her at the time, due to child abuse and leaving bruises on my son's arm. And the second one I had to do because she had taken him back over to the home where Michael Chaddock resides as well. So my concern is that his safety is at jeopardy just due to child abuse, neglect, and I ended up having to take him full custody and file basically emergency custody for him in order to keep him away from that household where he showed signs of being abused. He was doing not so well in school due to he was showing a lot of the same behaviors that he was seeing within the home. A lot of those behaviors pertain to biting, scratching, spitting on people, as Michael Chaddock had stated before in the cases pertaining to the restraining order that he had spit on my son's mom, and he was hitting people, such as another behavior that he was showing and seeing in the home where he had claimed that Michael Chaddock had hit his mom. So
Can I ask you a question, Mr. Miller?
Yeah.
So
Yes, Your Honor.
if I understand correctly, is that the parties have not agreed on a parenting plan that both feel comfortable with. Is that accurate?
I believe so. As of right now, it's supervised visitation unless Ms. Amasquita disagrees with that.
Okay. So Ms. Amasquita, what's your viewpoint as far as an agreed parenting plan between the parties? Have the parties come to an agreement or no?
No, there was no agreement.
Okay.
We were supposed to have it filled out today, but I was going to bring up a couple concerning things that might factor to the parenting plan.
Okay, so let me ask the parties. There was a petition for a parenting plan filed back in December of 2022. Then I see in June of 2023, there was an order by Judge Fassett. It was an interim ruling related to both parties attending a class, Love and Logic or Children in Between, communication through Our Family Wizard. Both parties get a DV evaluation, that Ms. Amasquita would have supervised visits with the children by the paternal grandmother, and that would be up to 8 hours of visitation a week, time and place agreed upon the parties, and that Mr. Chaddock would not be part of that visitation. And so is that what the parties have been working under as far as a parenting plan arrangement?
Yes,
Yeah.
yes, Your Honor.
Okay.
Everything that we needed to do have been done already.
All right, so you've done all of those things. All right, so, okay, let me just...
But I was gonna bring up just some things that were happening that were an issue for me.
Yeah, so let me, before you get there, Ms. Amasquita, I appreciate your wanting to share that. The procedure, I just want to make clear where we're at, is that there's a petition to have a parenting plan put in place. There's some proposed orders that have been submitted by the parties, and there's been declarations related to that, and some of these declarations are older. They've happened months ago. What each party's perspective was. We have a guardian ad litem. No, pardon me, don't. And then some proposed. Give me 1 second. Sorry. Okay. So I think, okay, so at this last hearing we had in the end of December. Okay, my apologies. The parties, just so I'm clear again, the parties are here today for the court to make a decision about a parenting plan. Is that correct?
Yes. Yes.
Okay, thank you, Ms. Amasquita. Mr. Miller?
Yes.
Okay, well, I'll let you know is that when I reviewed the file, the last thing I looked at was the December 26th hearing that we had. So I looked at the court's minutes from that. And there were some questions related to the protection order and the like. And then it said the court would like to see the parties make an attempt to come up with an agreement related to the parenting plan. And if there's agreement, then the parties could have it presented to the court. So I'll be honest with you. I didn't come into today's hearing thinking we were going to be talking about a full-blown parenting plan. And I apologize for that. And maybe I should have known that, but that wasn't clear to me. And I apologize that you took time out of your schedule today. So I'm really not in a position because I don't have all that information that you both submitted fresh in my mind, the different declarations and the like. So what I'm proposing is that we set this matter over so that I can have that fresh in my mind and each party's respective positions. And what I show is that Mr. Miller submitted a proposed parenting plan. I think it was maybe I have noted in my notes December 8th, but there may be a earlier one. No, December 22nd was the one that Mr. Miller filed. And then I believe Ms. Mesquita filed her proposed. I got it reversed. Mr. Miller submitted his December 8th, 2022. Ms. Mesquita filed her proposed on December of 2022, of December 22nd. So that's a lot of time, especially in the life of a small person, to have proposed orders. So I think we need to kind of take a fresh look at things as far as updated proposed parenting plans. If the parties have, you may feel like the proposed orders that you submitted previously are still effective and relevant. And if they are, then you can tell me that. If they're not, then I would expect that you would submit new proposed or revised proposed parenting plans, and then submit declarations to support the same. I'm looking at some different statements and documents that the parties have filed over a period of months, and it's somewhat difficult. It's somewhat disjointed in that there's a lot of documents and there's a lot of months to cover. Some of the information is dated. So this is my suggestion to the parties is that the parties would each submit proposed parenting plans. If it's the same as the one before, you can say that. If it's different, then you'd submit the proposed parenting plans and then submit a declaration of what you feel things should be. And that would give the court some clear guidance that's current and related to the situation of the child. And then we'd come back in roughly 2 or 3 weeks to address the issues. I'll hear from Mr. Miller as the petitioner first and what you think about that plan.
Okay. Yeah, I'm okay with that, Your Honor.
Okay. Ms. Amasquita, what's your input?
I'm okay with that, but would I be able to say a couple of issues I've been having since the last hearing that we had with I forgot her name, Miss Fassett?
Judge Fassett?
Yeah.
As far as that's obviously important in your mind, it sounds like, Ms. Amasquita. There's no motion pending before the court other than this issue of the parenting plan, which I'm not prepared for that today because I was thinking we were doing something else. So if you have issues related to Judge Fassett's order, that order's still in effect. That order still controls. If either party feels that order has not been followed, then you can file a motion for contempt in that you're alleging that order has not been followed. So while there may be concerns related to that, I'm not inclined to hear concerns about that particular issue without a motion pending before the court. There has to be kind of that a filing of a document with notice to the other side so they can be aware of what's happening and they can respond. So Ms. Amasquita, I appreciate you raising those potential concerns. I haven't heard them, but I think it's more properly set at a hearing where all parties have been given notice of what the topic is and that other side can respond, and then you can reply to their response, and then the court can be aware of things. So I'll politely decline that invitation to address that issue. As far as a date to come back, March, we could set it over 2 weeks to the 20th. If the parties need a little more time to get that in, it could be the 27th. Mr. Miller, what is your preference?
I'm okay with that, Your Honor.
Okay, Ms. Amasquita?
Let me look, hold on. I gotta look at my schedule. The 20th works for me.
Okay, it sounds like Mr. Miller, that works for you also. Okay, so we'll set the matter over to March 20th. This is what I'm anticipating, that the parties will file some type of declaration, each of you laying out what you feel that the parenting plan should be and why that's in the best interest of the children or child. And that if there's a different proposed parenting plan, you would say so and you would submit that. And if it's the same proposed parenting plan, you would say that and make reference to that. You would each then file your documents with the court and serve a copy on the other party so they know what you're having to say. And then both parties would be free to read what the other had said and then submit a reply, a declaration limited to 2 pages. So any questions, Mr. Miller?
No, I'm okay, Your Honor.
Okay. Ms. Amasquita, any questions?
So if I was to file a motion for contempt, would it be a different court date than the one on the 20th, or would I just wait for the 20th?
You could, if you feel like there's a motion contempt, you could note that up for a particular date, and you can check with the clerk's office for an appropriate date and time.
Okay.
So let's set this matter over to March 27th, and we'll hear that the respective positions of the party related to the parenting plan at that date and time. And then Ms. Amaskita, if you want to file, then that's probably gives everybody enough time to respond to that, and that could potentially be heard on that same date for any motions for contempt, and vice versa for Mr. Miller.
Okay.
All right, with that, we will conclude the hearing. Thank you both. We'll see you on the 27th of March at 9 a.m. Butcher's on the line.
Thank you.
Yes, I am, Your Honor.
Okay, welcome, Mr. Butcher. And then D. Stillwell, are you on the line? D. Stillwell, are you on the line? Okay.
Yes, I am. Oh, it's under the ESS.
Okay, all right. Welcome to you, Ms. Stillwell. And I see Ms. Turnbull is on the line. Thank you, Ms. Turnbull.
Yes, Your Honor.
So from my read of the case, we're here for a couple of different items. One is Ms. Stillwell's motion for contempt related to tax exemptions. We're also here for a presentation on presentation of orders related to child support, and then get an update as far as the GAL reports. And then there's a motion to change a parenting plan brought by Ms. Stillwell, and where adequate cause was found in the first part of December, and that Ms. Turnbull was appointed on her about a week after that. So let's take up, if we could, please, the first issue, which is the child support. This is of child support that sets net income of Mr. Butcher at $33,434 per month, and Ms. Stillwell at $2,650 per month, with a start date of March of 2024, and the amount of the support payment would be, I believe it's $1,116.28. Ms. Stillwell, did you receive a copy of that proposed order?
Yes, I did.
Okay, and do you have any objections to that proposed order?
I guess not.
Okay, when you say guess not, help me understand what you're saying there.
To afford to be able to live in my house, I'm not going to afford to pay my bills with the claiming. I'm also trying to figure out to prove that he is not Lennox's father.
Okay.
So I'm trying to do some other things as well.
All right, so going back, it looks like in the history of the case, on January 3rd of 2024, a hearing was held in which the court set the incomes of the parties at that $3,400 for Mr. and $2,600 for Ms. Stillwell.
Yeah.
Did you take time, Ms. Stillwell, to take those numbers and put those into a child support calculator to make sure that they were accurate?
Yeah, I did.
Okay, and do you feel that those numbers are accurate or not inaccurate or not accurate? Sorry.
They are.
Okay, just so you know, Ms. Stillwell, your audio sometimes comes in and there's kind of some strange noises, and it's a little hard sometimes to hear some of the words you're saying. So just know that if I ask a question to you to repeat, that's why.
I understand. I know it's kind of glitchy on my end as well.
Okay. So the amount of 1,116, you used the figures that the court set up, and you felt that that's accurate for the 4 children. Is that correct?
Correct.
Okay. Mr. Butcher, any comments on your end?
About the child support, no.
Okay. All right. So, based on the court's prior ruling of the net incomes of the parties, and with the assurance that Ms. Stillwell had put those into the child support calculator, and those are accurate numbers, I'll sign off on the child support order. The next matter we're here on, it relates to Ms. Stillwell's motion for contempt regarding the tax exemptions. And I just wanted to make sure with Mr. Butcher, there was a late filing received yesterday from Ms. Stillwell, where she indicates that the years that she's claiming that you took the tax exemption of the girls are different than what she originally said. Originally, she said 2022 and 2023 tax years. with this recent filing, she amends that and indicates that the tax years claimed for the exemptions were 2021 and 2022. Did you receive a copy of that document?
I did receive a copy of that, but I also submitted the tax returns that I have for like the last 4 years, which covers 2022. So that's fine. The 2021 tax year, I did claim them, but that was already addressed in a previous court hearing.
You said you submitted some tax documents to the court. When did you submit those?
That was, oh gosh, let me see here. I have the copies of the sealed documents that they scanned in here. See if they have a date on there. It was, I know it's been a while. I know they're already scanned in the system. February 23rd.
And yes, it was addressed, I believe, last year when this was going on. The judge said it was too late, but I never filed a contempt hearing. So now that I'm filing a contempt hearing, I believe I should be reimbursed for him claiming the girls when it is against court order.
Let me ask Mr. Butcher, you said that you filed that on the 23rd of December or of February, the tax documents, is that correct?
Yes.
How many pages approximately?
Looks like 6 pages.
And the reason I ask, I don't see it in the court file. See,
yeah,
I see a declaration that was filed by Mr. Butcher on the 23rd of February. It's a 2-page document. I see a proposed order of child support filed on the 23rd, and those are the 2 documents that I see filed. I don't see any others.
Well, let's see here. I was going to say I got copies from the clerk after it was done that had already been scanned in with the scanner. Let me see. Yeah, it came with the declaration, and yeah, it was an endorsed file on the 23rd. That's all I got. I know who put it in. The clerk that put it in. That's all I've got.
Yeah. So was it attached to your declaration?
Yes.
Okay. So it looks like just the declaration made it into the file. So those tax documents that you submitted, I have not seen those. They're not in the court file, unfortunately.
I know they're sealed, so I don't know if that has to be done separately.
No, if they're sealed, they would show and I would have access to them because they have pretty full access to those documents. So I guess my concern is that I'm not sure I have the full picture, at least from what the parties have submitted to the court. So I'm inclined, just because of that one issue related to the tax documents, because I think the tax documents, I'm assuming that they would provide good information related to the tax years 21 and 22 of whether the tax exemptions were claimed. And then there is information that Ms. Stillwell had brought up that potentially had been previously addressed and the like. So I'm kind of at a lack or a loss because I don't know what those documents say, and I haven't had the opportunity to review what Ms. Stillwell has indicated. So I think yeah, go ahead, Ms. Stillwell.
I'm sorry. I did file the declaration yesterday with proof of somebody claiming the girls on the taxes of 2022.
I see that you filed a
but I got a hold of IRS.
It's 3 pages in length that shows a single copy of a text message. I think you're from your father.
Yeah, I call my dad Fluffy, and somebody claimed the girls in 2022. But I got a hold of IRS, and they told me that they claimed the dependents, and I was not able to claim them. Yes, John did not claim him on the taxes, but who did?
Mr. Butcher, did you receive a copy of that declaration that Ms. Stillwell is referring to?
I did, yes.
Okay. So you're indicating that you claimed the children in 2021, is that correct?
Yes, I did claim them in 2021 after a year of, I had full custody and she only at the very end of the year had supervised visitation. And so I ended up claiming the kids for the whole year without knowing. And then the previous judge said that the next year that she got to claim them no matter what. And then I couldn't file any motions to change that until this year.
However, somebody claimed the girls to where I cannot claim them. And I cannot prove who claimed them.
Let me make sure that we're on the same page.
Somebody got
There's a child support order
hold
that
of their-
was filed in March of 2019 that sets out who gets the tax exemptions and what schedule that would occur. So it says the parties have the right to claim the children as dependents on their tax forms. Ms. Stillwell every year has the right to claim Alex and Lennox. Mr. Butcher every year, Elijah and Braden. So that's the document that I feel is the controlling document as far as the contempt. Do you agree with that, Ms. Stillwell?
2 years, I have not been able to claim the 2 girls.
So I'm not sure if you heard my
I
question.
don't know.
There's a March 2019 child support order that lays out who gets to claim the children and what frequency. So it looks like you have the right to claim Alex and Lennox every year, and Mr. Butcher has Elijah and Braden every year. Is that the controlling document that's the basis of your motion for contempt?
Yes, that is what I'm referring to, because that is how the taxes are supposed to be. It was never changed in court. And he's saying legally, because I do have a text message between me and him that says he got to claim the girls legally because I did not have them enough time. But according to court documents, nothing changed in court.
Ms. Stillwell, did you submit any documents related to the agreement between the parties as far as any tax exemption deviations?
No, there was no agreement of him getting to claim the girls. There was not. I have a text message. I can do a declaration and have that submitted that says that he claimed, since he had them more of the time legally, he was able to claim them even though there was nothing done in court.
Okay. All right.
So he was going against court order.
All right, Mr. Butcher.
Yeah, I'm not denying the 2021. Like I said, I was under the impression that when the parenting plan and everything else changed, I thought it all changed. But the previous judge did correct me on that when he addressed it before. Because like I said, there was a CPS came in and the children were removed for her home for safety reasons, and they were put in my full custody for the whole year. And I thought when one changed, like if the parenting plan changed, the whole thing changed. I was unaware that I need to file the papers. So I did claim them, and that's what was brought up to the judge previously.
Gotcha.
But
all right.
My question is who claimed the girls for years 2022, because I was unable to claim them. I have proof that I was unable to claim them because somebody already used the dependents, and I have had submitted that document with the court yesterday that somebody claimed them, a dependent that I'm them. So I'm being taken out for me that I don't know who is claiming them. I don't know if he's giving somebody else to where they claim them. It's not me doing it. Somebody's claiming them. And the IRS will not give me that information.
Okay. Mr. Butcher, as far as 2022,
so my concern is who is claiming my children to where I'm not able to.
Mr. Butcher, what's your
Somebody's
position related to the tax year
the IRS
2022 exemptions?
I can show bank statements and everything showing that I did not get anything more during that whole year than what is already on file for me claiming the 2 kids. There's my tax forms show that I only claimed the boys. I'm not sure if it was some sort of error, a typo. I know when I talked to my tax guy about the legality and I went on the IRS to see if I could find out as well, it is true. You cannot find out who claimed dependents. They will not release that information. He did say that it is a common error that happens with a lot of self-taxes, and you a lot of times have to try multiple times to go through. But if somebody claimed them, I am unaware. And like I said, I can show bank statements and everything throughout the previous years if you want that show that what I got on my tax return is all that was put into either of mine or my wife's bank accounts.
Mr. Butcher, did you file your tax return for 2022 so I can see who you claimed and how many you claimed?
Yes, I did file it, and I filed it jointly with my wife, and it shows that I only claimed.
Did you file it with the court was what I'm asking.
Yeah, that was one of the documents that I sent in. I have documents for
Is
all.
that the document that you filed yesterday or recently?
No, it was on the 23rd.
Okay, so that's the one that I don't have. Okay.
Yeah. And like I said, I'm confused on that because I even have, like, I have the paperwork stamped by the court, and I have the thing where it said they scanned it in with the cam scanner and everything.
Yeah, I don't have any reason to doubt you. It's just not in here.
Yeah.
So I think I think we need to put a pause on things so I can see those documents. I don't have them. I need to see them. It sounds like 2021, the issue's fairly clear, that Mr. Butcher claimed all of the children for that particular tax year based on his belief that he had the children. Well, he had the children for, it sounds like, the vast majority of the year due to some concerns related to mom. And so I think that's fairly established. It admitted to, they claimed all the children in contravention to that 2019 child support tax exemption provision. The 2022 tax year is murky at this point because I don't know, I haven't seen tax documents. So I'd ask that Mr. Butcher, if you could help potentially by contacting the clerk's office and resubmitting those documents that you submitted previously that are the tax returns, so I can actually see what the tax returns are and the claiming of dependence on that particular document. And I'm assuming that you filed that, or you provided a copy to Ms. Stillwell, correct?
Yeah, she should have been served with everything, but I think the tax documents, because they're sealed, so that should have just went to the court.
I do have them actually.
Okay.
And there is proof that he didn't claim them, but somebody claimed the girls because my dad tried several times and it was denied in years 2022.
All right, so that's what we need to see. I need to see those tax documents. So I apologize, we'll need to set it over. Just, Madam Clerk, do you have some comments? Okay, so the clerk was indicating that when those sealed documents were filed, they need to have a cover sheet on it. It says it's a sealed file, and there may have been some mix-up related to that. So if you could help us with that, Mr. Butcher, that would be appreciated, and get those sealed documents filed with the court. And then we'll come back on the 20th of March to address the 2022 tax exemption matter. So then that takes us to Ms. Turnbull and related to parenting plan input guardian ad litem report. So maybe Ms. Turnbull, can you just give us an update where you stand?
Well, right now the biggest issue is Ms. Stillwell has not been able to make her portion of the private pay payment. And we had talked about her maybe requesting from the court some relief to see if maybe the county would be able to make that portion of the payment for her. I don't believe she submitted any documentation or request for that, although we had talked about that. So
I did file a declaration to see if the judge could do that. I did file that declaration.
When did you file that, Ms. Stillwell?
What was keep breaking in and out? I did file a declaration on just last Friday. That I didn't file a motion. I filed a declaration. I didn't know if I needed to file a motion or what motion I would need to file. So
you filed that on March 1st, is that correct?
Amy told me. Yes, I did file a declaration saying that I have filed a declaration or the financial, and that was back in December, I believe.
The document that you filed on Friday,
my financials.
It's not in the court file. I don't have anything in the court file related to that. And was that your indication that your finances had changed, that you weren't able to afford the GAL fee?
My finances haven't changed since then, back in December, and I am financially not able to pay because I am barely able to even pay my bills right now.
All right, Ms. Stillwell, the connection is really poor, so I'm not getting the full import of what you're saying. So you said on March 1st that you filed a declaration related to your finances. Is that correct?
Correct.
That's not in my, it hasn't made it to the case file, so I'm not sure what that says. What does it say?
I couldn't hear you. I do apologize. My reception is really bad today.
Okay, can you do me a favor? Can you disconnect and come back into the meeting? Then maybe that'll help. Okay, great. So, Ms. Stillwell, the indication was that Ms. Turnbull had not received a copy of your pleading that you filed on Friday. Mr. Butcher indicated that he did receive a copy of your pleading received that you filed on Friday. The clerk indicated that sometimes documents are filed with the court, but there's a problem with the pleading, and so they're rejected and they're not filed. That may be at play here also. So I haven't received that information. Since we're coming back on the 20th of March to address the contempt motion, I think we need to come back also on the 20th of March to address the issue of the GAL payment, because I haven't received your declaration, haven't reviewed it related to finances and the like. I think I need to review that when we come back and talk about, make a decision on possibly reducing your contribution or having county pay the GAL fee. So I think we're going to do that. So we'll come back on the 20th for that issue. Other than that, I think that addresses the issues that were before the court today. Am I missing anything?
I don't think so.
Okay. So we'll be back on the 20th of March, and I'm not sure what's happening, with the filings and the like, but if you could please check with the clerk's office, make sure that all your relevant documents have been uploaded and are in the system. If they haven't been, make sure they get filed and uploaded into the system so we can have a meaningful hearing on the 20th and address these issues related to the 2022 tax exemption and also the GAL payment. Okay, so that if there's no other issues, that'll conclude the hearing today.
Thank you, Your Honor.
I did want to bring up something.
Because I've got a couple things I want to bring up. I actually did an issue with her over text message, and I gave it to Amy.
Ms. Stillwell, the communication is still garbled, and it's really difficult to hear what you're saying. So I'm inclined to come back on the 20th, and you can address any issues that you're concerned with on that date and time. And if it's something that you want to have addressed, you could file a motion.
I just wanted to also see if I could on her birthday on Sunday.
So any issue that you want a decision from the court, and generally needs to have a motion that prompts the discussion, allows the other party to respond. And without a motion, I'm not in a position to rule on any requests.
Okay.
Mr. Butcher, when I said we were signing off, it sounds like you spoke up also.
I was just going to speak up. I know on the last update we had last court session, we talked briefly about the guardian ad litem report and the state of the house. And there's been some issues between Dee and Alex with basically Alex not wanting to go over there. They text back and forth, and Dee told her she didn't have to come over if she didn't want to. But I was looking at, with the ongoing issues and the report on the state of the house, if we could strike overnights and the Monday visits for now until we get a full report from the guardian ad litem.
So similar response, Mr. Butcher, that I gave to Ms. Stillwell. If there's a request that you're asking for the party, there needs to be a motion filed and an opportunity for the other side to respond. So absent a motion being filed, I'm not in a position to respond to that request.
All right, understood.
And John, you might want to go through Alex's Discord, because she thinks it's funny to have somebody harm me, to come to my house, knock on my door, and shoot me. So you might want to address that.
So we're done with the hearing for today. If the parties have any concerns, you can file motions.
Yes, I'm here.
To rule on those. Welcome, Mr. Alton. Thanks for your patience. Ashley Keefe, are you on the line?
I'm here.
All right, thank you. And Heather Kell, are you on the line?
I am, Your Honor.
All right, thank you, Ms. Kell. Thanks for your patience also. We're here on a guardian ad litem motion to compel payment from Ms. Keefe, and also Ms. Keefe's motion for contempt related to failure to relay information and derogatory comments. Let's address the first issue from Ms. Kell on the motion for payment. Ms. Kell?
Yes, good morning, Your Honor. Thank you. We entered into an agreement, Ms. Keefe and I, it was a payment plan agreement for the remaining $750 on her balance that she owed toward her guardian ad litem fee. She was struggling to make that payment. I tried to be very patient and communicated with her frequently. When she stopped communication with me following the filing of the report, I reached out and said, if you're in need of a payment plan, let's discuss that. She stated that she did. She signed a payment plan agreement with me, and then following the hearing, she then stopped all communication. I've reached out several times since then, and have had no communication from her regarding what she still owes on that balance. I'm still open to working with her, but I do need to see some form of movement from her in that direction.
And the balance is 750.
Correct. Yes.
Okay. Thank you. Ms. Keefe?
I'm sorry, I haven't made any payments. I got put onto L&I. I hurt both of my elbows, and so I wasn't making very much. And I make like I was making almost $700 a month payment in child support for my other son. So I haven't been having the money for it. But I do intend to pay her back or pay for her services. It's just taking a very, very long time.
Did you communicate any of that information to Ms. Kell?
I didn't get an email. I don't really look at my emails, and so I kind of just was so stressed out I didn't really even realize any of it. So I didn't.
So I'm inclined to enter a judgment with interest.
Okay.
Ms. Kell?
That would be helpful. Thank you, Your Honor. I do want to remind Ms. Keefe, I have texted her. She's welcome to text me or call me on the phone. We've had communication that way in the past. So keeping up in contact is really what prevents me from having to take moves like this.
Okay, thank you.
So Ms. Keefe, I'm going to enter a judgment against you in behalf of Ms. Kell. It'll be charged at 12% interest. That's a statutory rate. So that'll go on credit reports and the like. And so it's in your best interest to pay that off and pay it off quickly, because that 12% interest is super high and can really increase that amount. So I'll
do I
sign
just
that.
pay her? Sorry.
Go ahead.
Do I just pay her through our little payment thing, or do I pay the court?
When a judgment is entered, the payment is given to the other party, to Ms. Kell, and then once she's received that, then she would enter a satisfaction of judgment document and saying that the payment has been made.
Okay, thank you.
Okay. Ms. Kell, any other comments related to that?
No, not at this time. Thank you, Your Honor.
Okay, thank you. 750?
Correct.
All right, very good. All right, so that concludes that portion of the hearing. The second portion is Ms. Keefe's motion related to the contempt. And I just want to double check with Ms. Keefe, did you serve a copy of those documents on Mr. Alton?
I was hoping that we could just dismiss this portion of it. I was wondering if me and Garrett could maybe sit down and talk, because I feel like we've gotten along good enough that we could settle on a 50-50 arrangement and get this figured out. And we used to be really good friends before this court stuff happened. I just feel like we could talk and figure that out and just stop the contempts and I would like to drop my contempt.
Mr. Alton, any response related to Ms. Keefe's motion to dismiss the motion for contempt?
No.
It's dismissed.
Thank you.
Both allegations that were filed, I'm dismissing both.
Thank you.
I'll submit a document that summarizes the dismissal, and I'll file that. If either party needs a copy, you can check with the clerk's office in roughly 2 to 3 days and get a copy of that.
Okay, perfect. Thank you.
Mr. Alton, any questions on your end?
No, that's it, Your Honor.
Okay, thanks everybody for your time today.
Thank you.
Thank you.
Thank you.